Good morning, everyone. I welcome you to all to our today's seminar on professional opportunities for CAs in arbitration. On behalf of Untitled Study Circle, I welcome our today's speaker, Advocate Inbavijayan, sir. Sir, welcome to our study circle.
Welcome.
It is a great honor for your presence at our study circles today. Disputes and differences in business dealings are very common. The overburdened cost and judicial system of our country are proof of the same. Disputes must be resolved, and undisputed result in business hinders a smooth flow and future growth of not only domestic trade but also of international trade. A dispute is normally resolved by way of litigation or through an attend dispute resolutions mechanisms. In litigation, a dispute is referred to court of law. It can be expensive and time-consuming and full of complexity. ADR is a system whereby disputants resolve their disputes with the help of an arbitrator, mediator. In our today's session, our speaker will take us through the different opportunities which CAs have in our arbitration. Before that, I'll request our Deputy Convener Ashish Chade to please introduce our today's speaker.
Good morning, Gaurang. Good morning, members. Good morning, sir. It's a privilege to introduce our today's speaker, Inbavijayan, sir. Inbavijayan, sir, was educated at Dr. Ambedkar Law College from the University of Madras. On completion of his legal education, he took up litigation practice at the High Court of Madras in 1997. His enthusiasm towards ADR made him pursue whole-time arbitration practice since 2001. So far, he has presided as sole arbitrator and represented as counsel in over 350 domestic cases, several thousands of small claims, commercial or financial arbitrations, and 15 international arbitrations as well. His areas of expertise include international commercial arbitration, maritime arbitration, international trade and contracts, IPR, construction disputes, finance and banking disputes, securities market, JVs, LCs, ADR, sale of goods, domain name disputes, and investment disputes. He has been accredited as an arbitrator in Hong Kong, China, Malaysia, Dubai, Egypt, Saudi Arabia, Maldives, India, US, and various other regional and national arbitration institutions. To add up, he is also the project advisor of an arbitration institute and inducted as member of ICCAs. He has been listed in the 2008 edition of International Who's Who of Commercial Arbitrators, and his name has been added up in the Chambers Asia Directory in the year 2010, 11, 12, and 13 with excellent references. In addition, he is also promoting the concept of ADR by way of writing articles and books, providing training courses, and gives lecture on arbitration and ADR in law schools, universities, chambers of commerce, and conferences worldwide. With this, I welcome Sir once again and request him to take this session forward today.
Thank you, Mr. Gaurav and Ashish. This is a great opportunity to address me before chartered accountants who are considered to be one of the important or key element in the ADR mechanism or the tools. Why I just tried to say is that now the arbitration is not considered to be a domain of exclusive the lawyers or the retired judges. We have to first of all understand what is the reality and how this particular concept work out and to what extent this is trying to resolve the dispute both domestic as well as international. I commonly come to know that any profession, whether it is the legal profession or the financial profession or the secretarial profession, any profession has its own advancement. And particularly when you look on the chartered accountants profession, it is having its roots predominantly connected to the economic development. One of the ingredient of the constitution, the economic development of any country, particularly when it comes to India, the ICA Institute is doing a wonderful job, and the chartered accountant professions has its roots connected with this key element of the democracy. Many of the professionals, particularly from the chartered accountancy domain, have a significant role, or they play an important role in whether it is the business, whether it is the industry, whether it's the service sectors, whether it is a manufacturing sector, whether it's a maritime sector, whether it is a commodity sector, any sector inside India as well as abroad. The chartered accountants are doing an excellent role, and they are very successful dealing with the financial aspects of any industry as well as the businesses. And this development, this increase in awareness and demands often compel to bring in these professionals to have a diversified view. As lawyers, we have a diversified view that we can represent any party in any forum at any point of time, subject to the limit which has been given by the Advocates Act 1961. We do or regulated by a particular legislation, like how you also have a legislation which is the Chartered Accountants Act 1949. It's a very interesting development that our professions are quite recognized by statute, and invariably the statute also facilitates and put us in a professional capacity and to also act as multifaceted professionals or diversified professionals. When you look on the Chartered Accountants regulations in the year 1988, specifically provides that chartered accountants in his professional capacity is allowed to act as an arbitrator. This was a very interesting thing when I found after having a lot of research with diversified professionals, particularly dealing with one of your certificate course for arbitration, now it is ADR. And when I was just doing the research, I found this legislation in 1988 itself, permitting a chartered accountant, allowing a chartered accountant in his professional capacity to act as an arbitrator. And interestingly, the terminology chartered accountant, or the profession chartered accountant, with its objective to be independent, to be balanced in the approach to any problem, can obviously or ideally be placed to act as arbitrator or a mediator or a conciliator, and effectively resolve the conflicts or disputes which arises among business associates, employers, employees in a partnership firm. These are very common element of conflicts or dispute which might arise in this area. As legislation itself gives an option for you to act in an independent manner and an impartial manner, you are the right person to preside or to be acting as an arbitrator or as a conciliator. Here, when most of us started mentioning that, okay, fine, now we have the option, we can become an arbitrator. Straight away, we'll think that we will become an arbitrator. Fine. Being an arbitrator, what is the essential thing we have to keep into consideration before finding how we are going to be appointed as an arbitrator? That is very, very important. When you look on this picture, this is somewhat like a collage brought in various aspects and various presentation. One says that in the left, it is court, in the right, it is arbitration. Don't go to court, go to arbitration. This is one picture. Another picture, invariably, a small element is trying to stop two big elements and not permitting those two big elements to touch upon. And if you look on the third one, it is somewhat giving a judicial feel. Fourth one, it is a very common tug of war. And the fifth one, like a pendulum. And the final one is entering into any documentary agreement or a contract. All these pictures invariably clearly make you understand that what is arbitration and what is ADR. When as a chartered accountant, when I am asking all of you, or in my early experience, when I was just asking, immediately the answer was that it is American depository receipt. No doubt, when you are looking into the most popularly we read the Hindu on the economic page, when we see, oh, ADR, fine, today there will be a huge variation in the stock market. The American depository receipt, some announcement has come in. That is the aspiration, no doubt, and nothing wrong in it. That people from the financial field accepting that, okay, it is American depository receipt. But the world is not confined to only American depository receipt. The world is wide, large, that it is accepting that there is an alternative dispute resolution. That alternative dispute resolution has to be seriously considered when we are divulging our efforts in a professional manner. It's very, very important. For an illustration, most of the chartered accountants have the clients which normally deals with partnership firms. It's very common. And when I started my practice, I had an experience that every partnership deed would be drafted by a chartered accountant. And the interesting thing is that it will be quite interesting, and it will be a customized document wherein it will facilitate the partners to effectively deal with the business rather than dissolve that business. In that way, it will be structured well by the chartered accountant. But the only thing, as a lawyer's perspective, when you are looking into that particular document, we'll be happy to see what is the dispute resolution clause. Whether the courts have been given an authority, or particularly like courts in Mumbai, or courts in Chennai, or courts in Calcutta, that is the first point for us to just focus on any particular document, that too, if it's a contract or particularly a deed, partnership deed. When you're looking into the partnership deed, when you find the word arbitration, I will be personally happy. If I find a word arbitration there, it is very sure that we cannot go to the courts. That is the understanding of the first picture. When you are given an option, courts or arbitration, and both the words are there in a particular contract, it is very clear that you can only arbitrate and you cannot approach the courts. Many would be trying to say that, no, our remedy, the final remedy is only available in the court. No doubt, you have that remedy in the court, but if the parties have consented to go for arbitration, then that is an authority which is autonomous, which is the party's autonomy, which will lead the parties only to arbitration. And if at all, if there is a chance to go to the courts, the court also is given an authority to refer it to arbitration. That is the thumb rule of the arbitration. In a simple legal language, the arbitration jurisdiction prevails over the court jurisdiction. That's all. When we have an arbitration clause, there are some exceptions, no doubt. Anything for any scientific invention or any legal principle, we do have some exception. But 95% of the capacity of the term arbitration leads us only to arbitration, because the arbitration jurisdiction prevails over the court jurisdiction. When we have time to look into the Arbitration Conciliation Act, which is the backbone for this entire arbitration, have a good reading on Section 8. That gives you a clarity for it. Why such a significant importance is given to the term arbitration. Having said this, this arbitration is one of the part of the ADR tools which are available in our country. ADR tool in other countries have its own wings as well as the opportunities. But In India, we have certain confined dispute resolution mechanisms which is taken under ADR. No doubt arbitration is considered because it is an alternative to a normal dispute resolution. Then we do have mediation, conciliation, lok adalat, as well as dispute review board. These are quite popular ADR mechanism in our country. One, arbitration, the very acceptable and common one. Second, the mediation, the most welcomed Western concept. Third, the conciliation, which is already there inbuilt in our system, which is also there with the arbitration law. Our arbitration law is not just Arbitration Act, it is Arbitration and Conciliation Act 1996. In that way, conciliation also we do have a law. And then we have the lok adalat, which is predominantly attached to the courts. We have very few opportunity to get involved in lok adalat. And finally, the dispute review board, which is very common in construction industry. For us to familiarize, the first three is sufficient: arbitration, mediation, and conciliation. These are the three major tools which we can effectively deal and we can have a constructive role in it. What is our opportunity? Anyway, this webinar is being organized by your conveners that you are having an opportunity. You can become an arbitrator. You can become an expert. You can be a counsel. You can be a consultant. Only four are there, nothing beyond it. All these four, how to explore? What is this opportunity? But before grabbing that, we have to analyze and accept what is the actual meaning of these ADR mechanisms. Right now, this alternative dispute resolution, what I was just highlighting for the past 10 to 15 minutes, is now changed into accepted dispute resolution, authorized dispute resolution, as well as authenticated dispute resolution. It is no way connected now with alternative. Now it has become authorized, accepted, and authenticated. Accepted, fine. All of you would understand that as a party, they are agreeing to go for ADR mechanism. They have accepted the dispute resolution. How it has become authorized? It is all authorized by our judicial precedent, the case laws. The courts are recognizing whether it is arbitration or mediation or conciliation. The courts are recognizing. For arbitration and conciliation, we have law, but for mediation, we don't have a law. As of now, we don't have law. We have only rules and regulations, but still the courts are recognizing and they are giving a legal sanctity for it by way of applying the law as well as the rules. In that way, it becomes authorized. And finally, it has become authenticated. How it has become authenticated? No doubt, the society at large is accepting that particular tool of dispute resolution. Now, this ADR is no more alternative. It is all authorized, accepted, and authenticated. That is the present situation of this ADR. And if it is going to be authorized or accepted or authenticated, we do also have the great opportunity. We have that opportunity. We are the person. We are the small element in the second picture. We are the person who's sitting in the middle, trying to just solve a dispute between two parties. We are the rope here, which is going to be the effective platform to retain both the parties. And we are going to be the pendulum. And ultimately, we are the person who are going to facilitate the parties' settlement, the parties' dispute management outcome. That is the binding dispute resolution process with a binding resolution of that particular dispute. All these six pictures makes ourselves so confident that ADR is going to be a constructive dispute resolution process wherein we are going to resolve the dispute. Looking into the picture, whether it is depicting Afghanistan, no. Whether it is depicting Qatar, no. Whether it is depicting the places like Philippines, the South China Sea. No, all these making comfortable. Looking into these pictures, the parties would be happy. And very interestingly, the disputing parties who have already entered into a contract or an agreement had a good partnership, and that partnership they wanted to smoothly dissolve or try to resume with that partnership. We as ADR practitioners, we can bring in the cordial relationship of the parties in a constructive manner. When we are doing an adversarial process in courts, I think many of you would have opportunity to even visit the courts or discuss with lawyers or judges. When you go to the courts, what happens? The very common thing we find that it becomes adversarial. Normal relationship between two parties, because of some difference, leads to dispute, and the dispute, if it goes to the court, their relationship would be totally like North Pole and South Pole. It becomes adverse. That process makes their relationship adverse, and that's why court process is considered to be adversarial process. Ultimately, a person is going to win, another person is going to lose. Not only the case, not only their legal position, their reputation also, because the court process is public. It is not private and confidential, which we can very well see in arbitration or mediation or conciliation. It is public. Any third person, a rivalry, a friend, an unrelated person, a stranger, can all observe what's happening in the court, can record and even publish. The confidentiality is not there. It's a public hearing. Thirdly, it is time consuming. Huge time is taken when we go to the courts. It is good, one way, good for professionals like us, as well as one of the parties. We have to accept that. But still, that is not good for the parties in a long-term perspective. The parties are involving in some business. The parties are involving some relationship. The parties are involving in some constructive outcome which is good for the society at large. Because of this dispute which has been taken to the courts, the delay, the cost, the adversarial situation, the public hearing, all put a strangle and a chaotic society, and ultimately the harmonious society would be challenged. Why give such opportunity? Our disputes, why it has to go to public? Why our dispute has to be taken by a person who's been designated by the state? The state designated persons are there to deal with constitutional issues, criminal issues. They are not there to deal with commercial disputes. That is very important. The commercial disputes are to be resolved among the parties themselves. Then only the world, which is now considered to be a globalized society with liberalized reforms, as well as the investment climate, which is very, very important for any investors, whether international or foreign investor or a domestic investor, the investment climate should be conducive. Ultimately, it is socio-economic combination which has pulled us to go to ADR. That is the alternative dispute resolution, having the new concept of authorized, accepted, as well as authenticated. It is some interesting introduction what I wanted to share here. Resolving dispute is a skill, no doubt, as well as a necessity today. The skill is a characteristic of a person, whereas the necessity is a situation in which that character is put to practice. Very simple. It starts from home. I think I could see some young people like Ashish and Gaurang. Hope all others also young. Presume that you also consider to be further young, that you are studying in a college. You are doing a BCom undergraduation, and at that point of time, you are quite interested to purchase a mobile, a smartphone. Happily, Gaurav and Ashik would say, I want to have the iPhone 12 Pro. Whether these two people can purchase it as a student? It's very hard. But they might have some illegal way to raise that fund and do it. But the society won't allow them. They have to do only the legal manner to approach and get. Okay, fine. The legal manner, whether they can borrow money. They can borrow, but what is the collateral they can give? No one would consider a college-going student to have a capacity, a financial capacity to repay or whatever the legal, the financial terminology would considered by the bankers. Then what is the source for Gaurang and Ashish? The only source is parents. And when we look onto the parents, as these two boys would be quite very happy to target the mother, the soft target. But we think that it's a soft target, but ultimately that is the rock which controls the entire family effectively. But anyway, we can approach her. Whether it is easy to convince her, it's very hard. How we are going to convince? Whether you are going to threaten your mother, if you're not arranged for the funds, I'll stop going to the college. I won't study properly. I'll just literally sleep, enjoy, eat, sleep, do the routine work, which is irritating, which is going to spoil your studies. Whether she'll be convinced, she knows that you people won't do it. Or at least if you're trying to do for hardly for 2 or 3 days, you can do. Further, what you'll try? Okay, you'll try a constructive way. The first one was a destructive, second one is constructive. Okay, if you get me that mobile, I'll score the best mark, 90% plus. It is anyway imaginary figure, but still we can try. At least in the accounts paper, you can try. Whether she'll be convinced, reasonably she might be convinced, some 30% or 40%. Still, you have to convince her. How are you going to convince? You can have a comparative analysis. You can just say, one of your friend who has also taken that particular, purchased that particular iPhone 12, instead of going to the library, spending time, he is sitting at home, using the best app in that mobile and studying, and he is very successful in his studies. Such a comparative study can put, like him, I will also become. In addition to what I'm scoring, I can also perform very well. I can excel. She will be somewhat convinced, but still there will be a small portion we can't convince. The last one, we can just simply say, I'll go to the 4th floor and I'll jump. Whether she'll be convinced, she will be very cautious. Okay, this is the only child, I should not lose him. But still, some 5 or 10% there will be a balance for her to be accepting your stand. All these process, what you tried was a negotiation. A very simple negotiation with your mother to get the fund for that particular mobile. We can, but it can't be 100% successful, 90%. She'll approve. Not iPhone 12, you can get iPhone 10R. It is half of that price, that is enough. Another 50% I will give you for a motorcycle. You'll be happy. It's a negotiation technique, what she has done. Now you got a smartphone as well as a motor vehicle or a motorbike, a two-wheeler. You will be happy. This is a very common negotiation which is also applicable in our business arena. The only aspect is that positions and interest of the parties. That is very important. The positions and interest leads to even the legal duties and the obligations. In the larger scale or the smaller scale or a mid-level scale, all these are differences which ultimately become disputes and finally becomes a conflict. And for that to understand, there is a very interesting judgment, English court judgment. You can just make note of it. It is Halki Shipping, Halki, Halki Shipping versus Sofex Oils, SOFEX, Sofex oils, wherein the English commercial code try to give a clear definition of the term disputes. It includes all disagreement, claims, the positions, the interest of the parties. And we have to have a proper dispute to be taken to ADR mechanism. That is the reason why this conflict management is very important. And we, future practitioners who are going to have a good career in arbitration, should have that characteristic and should also deal effectively that particular necessity which has been arises with all our professional expertise. Our professional expertise has to be well balanced and it has to be brought in as our personal skill, considering the positions or the interest of the parties. In that way, you can be a really successful dispute resolution professional. And anyway, today's, I think whether it is a court or any other tribunal are all overburdened, and the courts having its own procedures. There's a civil procedure code and multiple legislations which keeps on prolonging the matter. No doubt, those are time-tested legislation, but these are very essential part of the court system. We can't just avoid it. That is good for only important, complex, as well as the constitutional issues, not for our commercial issues. The courts are itself accepting, and now we need to have a constructive role in this particular dispute or the particular dispute resolution platform. What is the role available? As I just mentioned earlier, there are 4 roles. 1, arbitrator. For me, we had to keep it in the last. First has to be consultant. Second has to be counsel, representing the parties in all these ADR mechanism. And third, as an expert. All these are very, very common role which we can come across in arbitration, mediation, or conciliation. What role as a consultant you are going to do? What is the constructive role you are going to do in arbitration? As a counsel, or as an expert, or as a consultant? We can just look into. As a counsel or consultant, a chartered accountant is normally can represent. They can represent like advocates represent the clients before authorities, like how we are appearing in NCLTs, the tribunals, then the regulatory bodies like banking regulators, there's RBI, capital markets, SEBI. We can also represent the parties, appear for the parties before the arbitral tribunal. And here, a chartered accountant can specialize in arbitration matters, particularly connected with common breach of contract, with having financial implication, then the insurance sectors, then the aspect of P&L issues, then the securities market fraud, the commercial disputes, the property related issues, then the lease arrangements or lease agreements. These are some example. The chartered accountant is the best person to represent the parties, to file a claim on behalf of the party, to tender the arguments before the arbitral tribunal for the parties, and to some extent facilitate witnesses when it comes to commercial aspects, guiding the witnesses for deposing before the arbitral tribunal. And the first important role as a counsel or a consultant for a chartered accountant is that drafting arbitration clause or a drafting arbitration agreement or an ADR agreement or a clause. It is a very important task for a chartered accountant or a lawyer to begin with. When a client is approaching you to enter into a partnership deed, or nowadays it is LLP agreements, or any other document which is pertaining to any financial transactions, you have to educate the client, convince the client, and ultimately incorporate an arbitration clause. Drafting arbitration clause is a great skill, and that is the abundant opportunity for chartered accountants in arbitration as well as other ADR mechanism. When we are just facilitating an example, the same example, partnership deed, put the arbitration clause. There are two options for us to put. One we call ad hoc arbitration clause. Another is institutional arbitration clause. Which one you like, you just put it. Which one the parties accept, you put it. Which one in a long-term perspective, you put it. But as professionals, we have to suggest, we have to recommend the best arbitration clause, which is best considered for interpretation of the courts. Ultimately, the courts are going to interpret any contract that we have to cautiously deal. Presently in India, the trend is that we have to better incorporate institutional arbitration clauses. It is very clear that from the year 2016, institutional arbitration is promoted by the government itself. The Niti Aayog, the Planning Commission, the former Planning Commission, has recommended parties to go for institutional arbitration, and the law, that is the Arbitration Conciliation Act 1996, had several amendments in 2015, 2019, and now 2021. 3 amendments, wherein interestingly, all the 3 amendments, the lawmakers is facilitating the arbitration to be institutional arbitration. That means we have a great opportunity when we are going to associate with institutions, particularly ADR institutions. ICA is also one institution which is going to facilitate ADR by way of empaneling people into arbitration by joining the certificate course and qualifying it. That is a different one. But this is one example of institution. There are many other institutions like Indian Council of Arbitration in Delhi, Mumbai Center for International Arbitration in Mumbai, then Indian Merchants Chambers attached to the, earlier it was Bombay Chamber of Commerce and Industry, now it's independent, IMC. IMC has a court of arbitration. Likewise, there are many institutions, ADR institutions. We don't have a regulator. As of today, all these institutions, like a mushroom, has grown. There is no regulator. In future, there is a regulator which is likely to be titled or christened as Arbitration Council of India, ACI. That is a recommendation given in 2019 Arbitration Conciliation Act amendment. All these are putting full stress and facilitating institutional arbitration. What we have to do? Just I earlier mentioned, we have to be prepared to draft an arbitration clause. To draft an arbitration clause, you just keep 5 things in mind. One, in that arbitration clause, we have to put what type of dispute has to be arbitrated. Like a bullet point you can write. No need to just put it as a paragraph. Just as a bullet point under that particular clause, you can put it. What type of disputes has to be referred in this contract to arbitration. Secondly, how many arbitrators are to be appointed if a dispute arises? We can have any number of arbitrators, more than 1 we can have. 1 is the minimum. We are not accepting our mathematics 0. We need to have only 1, at least 1. 1 arbitrator or more than 1. We can go to any odd number of arbitrators. That is the second important thing we have to try to put it in the clause. Thirdly, we have to be very clear that what law or what institutional rules, arbitration rules or mediation rules, which will be applicable for that particular dispute resolution process. In India, if you are going to do, then it is going to be the Arbitration Conciliation Act, no doubt. Whether you are mentioning it or not, it is very clear. But if you want to put an institutional arbitration clause, we have to mention as a third point what arbitration rules would apply. Arbitration rules of Mumbai Center for International Arbitration, arbitration rules of Kuwait Foundation Conflict Resolution International. These are some arbitration institutions that has to be clearly mentioned. Fourthly, we have to mention the place of arbitration, where the dispute is likely to be taken when a dispute arises. The arbitration has to be conducted in which place. And finally, the fifth point, what is the language? We had to mention this is going to be the language of the arbitration proceedings. That's all. If you have these 5 elements in your arbitration clause, then there is no issue and your client would be the happiest person, even if a dispute arises in that particular contract or a deed, they can smoothly commence the arbitration process. This is the first task for you to do. If you are capable to draft an arbitration clause, you will be the master, you will be the subsequent counsel for that particular arbitration. Very, very clear. Once you incorporate, if a dispute comes, the first visitor to you would be that client who have reached you and ultimately where you facilitated incorporation of that clause. He will just bring that particular clause and ask what to do. Whether they are a corporate or an individual or a partnership firm or a proprietor, whoever might be, when actually a dispute comes, they have to be guided effectively by us. That too, if you have drafted, you are the author of that particular contract, they will invariably come to you and then you can effectively guide that party in a professional manner as a counsel. The first role, what you did as incorporating that clause was your role as a consultant. Now you are changing into a counsel. You are going to appear on behalf of that party before an arbitrator or an arbitral tribunal. That is a great opportunity and you are the best person to effectively deal the technicality of that particular dispute and bring before the arbitrator. And the same, if the parties are having a high value dispute or it is not too much on financial issue, it is much on legal issues, it is much on another domain like engineering domain, then you can also be having a role in it as an expert. The financial part of the dispute which has evolved in that particular contract can be dealt effectively by a chartered accountant or a cost accountant, and you people can also act as expert. An expert report is very much required to be submitted by parties, as well as sometimes the arbitrators also have to be guided by experts. Because arbitrators, we can't just expect that the arbitrator is like Lord Shiva. An arbitrator also has his own limitation. An arbitrator might be expert in finance. He might be expert in law, particularly commercial law alone. If a dispute comes which is not in the expertise of that particular individual or group of individuals, then they also need to engage expert. And that expert would be, for financial dispute, a chartered accountant. That is the third opportunity, and the ultimate opportunity is arbitrator. In the same dispute, you are facilitating as a consultant and counsel or an expert, then in this matter, you have to approach an arbitrator before getting the assistance of the court. You have the power on behalf of the client to appoint an arbitrator, and in such situation, you can also appoint an arbitrator who has a qualification chartered accountant. You need not appoint always a person with legal background. You need not appoint always a person from the judiciary. They are the persons of good quality, the best qualities, but still your dispute is on technicality. Your disputes on particularly on that particular domain, finance. We can't just expect, we can expect some retired judges. We can't appoint a sitting judge as arbitrator. That is restriction. A retired judge, he might have a good qualification of chartered accountancy. He might be considered. But still, you have an authority also to appoint an arbitrator. In that platform, you are going to appoint a person with financial background, not a person with legal background. There is no restriction for you. If you look into the law, who can be an arbitrator? What answer you'll get? A simple answer given under section 11 says that a person of any nationality can be an arbitrator. That's all. Not even an Indian national. Even a foreigner can come. A person even without any qualification can come and sit. A person who has just attained a majority without having any even undergraduation, he can sit as an arbitrator. There is no restriction. There is no restriction for anyone to sit as an arbitrator. The only thing the restriction is given is that if the arbitrator has some relationship, the law is guiding on it. They have included some annexures like categories of relationship between the arbitrator, the parties, arbitrator and the dispute, arbitrators and the representatives. If we come under those relationship categories, then we might be restricted. Otherwise, there is no restriction. And interestingly here, there was one great development in the year 2019. In the Arbitration Conciliation Act, they included 8th schedule, Roman letter 8th schedule, wherein they prescribed certain qualifications and experience for a person to act as an arbitrator. It was a very innovative task which was taken in 2019, but right now you can forget about it because in 2021, in the amendment, they have removed that 8th schedule. But a good part of 8th schedule is that it brought in certain categories of persons who can act as an arbitrator. And in that, one was chartered accountant. 10 years experience, any, whether it's an advocate, a chartered accountant, or a company secretary, or a cost accountant, or a graduate, or engineering graduate, or a specialized, a person with specialty in telecom industry, or insurance sector, or maritime sector with 10 years experience. They had a slab of 10 years experience, but that inclusion was omitted in 2021. That means right now we have the original version of anyone can act as an arbitrator. Any individual can act as an arbitrator. And if you look on one institution, what I just mentioned earlier, the Indian Council of Arbitration, which is an arbitration institution based out of Delhi, having branches all over India. In a particular clause, it is mentioned a broad categories of qualifications and experience. I think it's clause 3, Roman letter 3. Broad categories of qualification and experience for empanelment as an arbitrator indicates that chartered accountants having 15 years of professional experience are eligible for empanelment as an arbitrator. It is an old rule which has been given in Indian Council of Arbitration, but now it has changed a lot. But the inclusion of broad categories of qualified and experienced person or professionals, that is very important. It is not confining only with legal category. It is broad. Anyone can act as an arbitrator, even if it is an institutional arbitration. The only thing what we have to do here is that once the 2021 or 2019 recommendation of Arbitration Council of India is created, just wait for that regulatory body. Once it is formulated, then they are going to take two interesting tasks. One task is that they are going to grade arbitration institution. What are there already in existence, like ICA, MCIA, or ICAI, all these institutions, they are going to be graded subject to their application. That means they are going to be recognized as arbitration institution, which can function as institutional arbitration service providers in this country. And second interesting thing, they are going to accredit arbitrators. The Arbitration Council of India is going to bring a category of panel or pool of arbitrators in multiple sectors, like panel of arbitrators from advocates, panel of arbitrators from chartered accountancy, panel of arbitrators from engineering bodies, panel of arbitrators from maritime industry. Likewise, they are going to bring multiple categories of grade accredited arbitrators. Our task is to first get that accreditation with all your qualifications, like academically doing some certificate course, like the certificate course of ADR of ICAI, or any other courses which is being considered attached with some law schools. You try to do this diploma or certificate course or PG diploma and have a good exposure as counsel or consultant in arbitration, so that you might be considered in that panel or pool of arbitrators. Why? Because once you are accredited in that panel or pool of arbitrators, your names would be de facto considered in those graded arbitration institutions also. Interestingly, when we have an institutional arbitration, for example, ICAI, in future, if it's been considered as an institutional arbitration service provider.
Sorry, sir,
Yes.
just 1 second. Sir, presentation is not visible.
No, I'm not sharing. I'm not sharing.
Okay. Fine, sir. Okay.
Yeah. When we are just going into these institutions, particularly ICAI, when ICAI is going to consider their panel or list of arbitrators, they are going to bring a criteria for who are eligible to be considered in that panel. At that point of time, once you have been accredited under the ACI, then de facto you will be included in the panel of arbitrators of the institutions like MCIA, ICA, or any institutions, KFCRA or IMC. All these institutions are very well accepting once you have been accredited as arbitrator under the very interesting development of the 2019 amendment, that is Arbitration Council of India. Now I am back to the presentation. What type of disputes are very common? These are some examples I just brought in here. Financial or contractual commercial dispute, maritime or shipping disputes, international or cross-border commercial disputes, life science matters, research and R&D agreements, sports disputes like example disciplinary sanctions or player eligibility. These are some disputes, but very common disputes which we come across and which we have a lot of opportunities are sales agreement, licensing agreement, financial agreements, joint venture agreements, development agreements, and investment agreements. These are very common, which includes, this is a macro level, sales, licensing, financial, joint venture, development agreements, and investment agreements. All these are very common platform of agreements which facilitates arbitration. And while we are trying to say that these type of disputes are available, we have to look into what is the expected qualification for a person to act as an arbitrator. As I earlier mentioned, anyone can be an arbitrator, but still we need to have certain qualities for a person to act as an arbitrator. What are those qualities? Anyway, no one would accept the aspect what I'm going to share now. One, we have to be independent. Whether you are independent? No. Next, we have to be honest. Whether we are totally honest? No. Third, whether we have to be impartial. Whether we can say that we are always impartial? No. Whether we are going to say that we are unbiased? Not always. We are biased in certain situations and certain issues. The thumb rule is that the arbitrator, prospective arbitrator, should have a quality which is independent. He has to be impartial. He has to be unbiased, and ultimately he has to be a neutral. If you are a neutral person, then you are the best person to be considered as an arbitrator with certain qualifications subject to the domain or the expertise what is being expected. If you are dependent on either of the parties or either of the parties' representative, then you are not the right person. If you are partial with one of the person, if you are biased with one of the party, then you are not the right person to act as an arbitrator. All these is not my suggestion. It is all taken from a soft law which is called IBA guidelines. If you are interested, you can note down it. IBA guidelines on conflict of interest. It's a very interesting soft law which is not mandatory for us to follow, but it is a guiding principle to avoid persons from appointing as an arbitrator. We have to cautiously look upon that. If you want to have an opportunity to sit as an arbitrator, we should not come within that purview of that guideline, the relationship. And in India, interestingly, in 2015, in the Arbitration Constitution Act 1996, this soft law has been incorporated into 5th and 7th schedule. 34 types of relationship has been included. I will try to share one so that all of you would be interesting to look into it. When you wanted to get an opportunity, you should not come within this, but it's an exhaustive list. We have to try to go away from it. Yeah. The following grounds give rise to justifiable doubts as to the independence or impartiality of the prospective arbitrator. Okay. Look into just point number 1. Yes.
So the screen is not visible.
It's not visible?
No, sir.
Now it's visible?
Yes. Okay.
Yeah. 5th schedule, which is having a cross reference to a particular provision, have some 34 categories. Look here, some 1 to 34 it is included. And I'll just go to 1. Sorry for scrolling it so fast. Okay. 1. The arbitrator, that is a prospective person who is likely to be appointed as an arbitrator, is an employee, consultant, advisor, or has any other past or present business relationship with the party. If assuming that you happen to be an employee of another party, whether you can arbitrate, you should not arbitrate. But before 2015, in India, all government contracts or state contracts, if you see, the general manager or the chief chairman and the managing director of a particular entity which is a party to that particular dispute, shall be appointed as an arbitrator. That word would be there. They wanted to remove, and this was not creature from India. It is a recommendation of that IBA guidelines. And now effectively in India, that particular situation has been removed. If you are an employee, if you are an advisor, if you are a consultant, either past or present, assuming that Mr. Gaurav is consultant of a company A, or he was consultant 5 years back. Still, if company A is involved in a particular arbitration, Mr. Gaurav, if is being considered as an arbitrator, he will be removed or he will become prohibited. He will be prohibited to act as an arbitrator as per this point or category number 1. Why I am trying to say is that this item number 1 to 34, which is given in this 5th schedule, is also reproduced in 7th schedule. I'll just go to 7. Look here. The arbitrator is an employee, consultant, advisor, or has any other past or present relationship with the party. Same. First 19, 1 to 19 of 5th schedule has been reproduced in 7th schedule. And here, if you look on 7th schedule, the cross reference to the provision is not 12(1)(b), it is 12 subsection 5. Just keep it in mind, 12(1)(b) and 12 subsection 5. I'll straight away go to 12(1)(b) first. Yeah. It's visible? 12(1)(b). I'll read that alone. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose in writing any circumstance, go to straightaway B, which are likely to affect his ability to devote sufficient time to arbitration, and in particular, his ability to complete the entire arbitration within a period of 12 months. And they have added 2 explanations. The ground stated in 5th schedule shall guide in determining whether circumstances exist which give rise to justifiable doubts as to the independence or impartiality of an arbitrator. And 2, the disclosure shall be made by such person in the form specified in 6th schedule. This is a cross reference. This is no doubt when a person is likely to be appointed as an arbitrator, he is going to give a declaration. And in that declaration, he is going to look into 5th schedule and he is going to depend upon that B explanation 1 and is going to disclose. This is very common and no doubt there is no great impediment here. When we move on to subsection 5, this is very interesting. Notwithstanding any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in the 7th schedule. In 12(1)(b) explanations, it was mentioning about 5th and 6th schedule. Now it is mentioning about 7th schedule under subsection 5. Shall be ineligible to be appointed as an arbitrator. There is one exception, provided that parties may subsequent to dispute have arisen, waive the applicability of this subsection by an express agreement, then it's an exception. But otherwise, if your declaration falls under any of the categories specified in the 7th schedule, then that person shall be ineligible to be appointed as an arbitrator. It's a very, very cautious note for all of us an aspirant person to act as an arbitrator. The world is very small. When we are trying to get, or when you have been proposed as an arbitrator, you have to give a declaration now. When you are going to give a declaration, your declaration is going to look into the fifth schedule, the points, and in that fifth schedule, if it is beyond 19, from 20 to 34, you are much safer, or sometimes you won't come within either of these 34, any of these 34, that you are the safest, you are the green signal. 20 to 34, you are in orange. 1 to 19, you are in red. That's all. If you are in 1 to 19, then you are ineligible. Like a traffic signal, you can't proceed forward. You are blocked. If you are orange, if you are within 20 to 34, no doubt, subsection 5 doesn't come. You're safe. But still, there is a chance of partiality. That's all. But if you are not coming within that 34, then it's a green signal. You can just proceed as an arbitrator. Getting the first appointment, it is the Himalayan task, and the same way, while getting that, you have to put all the declaration, not only in your first case, even if it is your 1000th case, you have to give this declaration, that too from 2015, not before. Earlier we were enjoying. We need not worry about all these. But now it is very clear, the IBA guidelines on conflict of interest has been incorporated clearly in our law as 5th, 6th and 7th schedule. And if you look on 5th schedules, all these categories, the 34 categories, what has been given, find it, and then you can proceed. The 5th schedule is very clear. One, I just mentioned this. You can go to the last point, 34. The arbitrator is a manager, director, or part of the management, or has a similar controlling influence in an affiliate of one of the parties, where the affiliate is not directly involved in a matter in the dispute. A and B are there. The arbitrator happened to be A Square's manager. A Square is an affiliate company of A. But still, there is some relationship we have to declare. But for our convenience, these three explanations are given. Very interesting for us to note it, because when you are having a prospective appointment, the term close family member has to be considered. Close family member referred to spouse, sibling, child, parent, or life partner. The term affiliate encompasses all companies in one group of companies, including the parent company. And for removal of doubts, it is clarified that it may be the practice in certain kinds of arbitration, such as maritime or commodities, to draw arbitrators from a small specialized pool. In some maritime and commodities, we don't have much experts. In such a situation, we are confining with only few people having repeated appointment. Why this explanation is given? Because of this point, which is given in 22. I think it's visible to all of you. Category number 22. The arbitrator has within the past 3 years been appointed as arbitrator on 2 or more occasions by one of the parties or an affiliate of one of the parties. A and B, same example in taking. A and B is that A and B, A has dispute, not only B, A has dispute with C, D, E, F. Assuming that X is appointed as arbitrator in the first dispute, A and B, and in the second dispute also, A and C, at that point of time, as per 22, the arbitrator, that same X, has to declare that within the past 3 years, he has been appointed on 2 or more occasions. For that purpose, there is some explanation given, explanation number 3. Why? Because in maritime and commodity arbitrations, we have very limited number of experts. In such a situation, one person would be appointed in 10 cases, wherein party A would be involved. That can't be restricted, but it is applicable for all other areas of disputes. These are some interesting components which has been included in 15 amendment. Hope we are very clear on this. We have to give a declaration, and when you are going to give a declaration, if it comes within 20 to 34, you are free, you are in the orange list. It is not, you have nothing to declare, you are in the green list. When you are coming within 1 to 19, you are in the red list. Then 7th schedule is attracted. Be cautious. While taking an appointment as an arbitrator, you have to very cautiously look upon all these 34 and then proceed with your particular case. Otherwise, you will end up in a serious issue and your award would be ultimately challenged or set aside. Why? Giving that opportunity for the parties. Yeah. Some eligibility aspect which I could find from the acts or various legislations. Section 2, subsection 2 of Chartered Accountants Act 1949, read with what I had a research, read with regulations 191 of the Chartered Accountants Regulations, specifically provides that a CA in his professional capacity is allowed to act as an arbitrator. Anyway, you are going to get remuneration. There is no bar in it. Indian Council of Arbitration, as I earlier mentioned, recognized chartered accountants to act as an arbitrator by having a separate panel of arbitrators from chartered accountants profession. Under clause 2 of section 43J, it is a new development of the Arbitration Conciliation Amendment Act 2019 that was recommending the 8th schedule. That is a great chance for chartered accountants also to get involved. And chartered accountants, within the meaning of Chartered Accountants Act 1949, having 10 years of practice experience as per 8th schedule, they can also act as arbitrator. Now it has been removed. Now anyone, there is no restriction. You can have just 1 year experience or not even 1 year experience, you can act as an arbitrator. What are some skills? These are some basic skills. What is required for a person to act as an arbitrator? Problem solving skill, good interpersonal skill, then the knowledge and experience of the relevant sectors. And to some extent, you need to know about the law. No doubt, all the legal principles are being considered in the Arbitration Conciliation Act. And this law is applicable for arbitration. If a law is going to be applicable, then there is an aspect of interpretation of that law. To interpret that law, you need to understand that particular law and its legal principle. For that purpose, reasonable knowledge of law is also sufficient. And most interestingly, the ability to be impartial, unbiased, independent, and ultimately evaluating evidence and making effective decisions are required. These are some skills for an arbitrator. Getting opportunity is quite easy in certain platform. Having a good networking, we can do it. But at the time of appointment, you have to be impartial. You have to effectively evaluate evidence and make effective decisions. Why? Because this award, the decision, what you're giving is going to the courts for enforcement. You are not going to enforce. You are the person who is going to complete the arbitration and give the judgment. That's the award. And that award is going to the courts, and the court has the only authority to enforce it. And that way, your award has to be a well-speaking award with reasons, and it has to be effective decisions. Okay, what are the work experience which is normally considered by most of the institutions as well as parties is that some exposure in arbitration. Some exposure in the sense you can act as a consultant or counsel or expert to act as arbitrator. First three, you are always eligible. The third one, once you have a reasonable number of years of experience, you will become that expert. Counsel and consultant, the day one you can start. For experienced persons, you can straight away start with even sitting as expert or sometimes arbitrator. That is very important in a particular technical domain. Associations like AIA, ICC, these are some arbitration institutions and forums. LCAA also gives some opportunity. These opportunities for some people to go as interns. You can go as secretarial staff. You can go as a voluntary the secretarial councils to guide their cases. In that way, you will be exposed to arbitration, and your profile would have some value additions and testimonials for you to get into arbitration. And as I just mentioned, your general dispute resolution experience is always valuable. That no doubt. Starting from your smallest dispute, how you are resolving in an informal way, you can try to bring it to arbitration so that you will be considered to act as an arbitrator. Okay, now why India? Anyway, we all are Indians. We are in India. We are going to get an opportunity first from our country, not outside our country. Now, India, the Indian lawmakers and the Indian judiciary are all pro-arbitration. When you are reading the newspapers, when you are reading into the judgments, when you are just going to watch some seminars or webinars, every persons, the stakeholders in the judiciary as well as the legislature are promoting arbitration. That means they are not a hindrance to arbitration. They are asking the parties to try to resolve the disputes through arbitration, mediation, as well as conciliation. And interestingly, the Indian companies are now considered to be Indian MNCs. They are spreading their wings worldwide, and now the international jurisprudence, whatever law in that country, is also now interchangeably used, and we have the arbitration law specifically as a harmonious law. Our law is not a creature from our lawmakers. It is the UNCITRAL model law. The United Nations recommended a certain guidelines for arbitration. That guidelines has been adopted in our country. India is one among some 100 countries which have adopted such a law. That means, like India, there are around 99 countries having similar arbitration legislation. If you are going to arbitrate here, you can also effectively arbitrate in another country. Like Sri Lanka, we can arbitrate. You can just go to UK and arbitrate, because our law and that country arbitration law are similar, because both comes from a harmonious system, that is a model law. That is why we have to choose India to start our career in arbitration. No doubt, we have that competition, but still, this is the greatest opportunity, and this time period has to be effectively used by all of us to explore our opportunities in all the four. It is not that becoming an arbitrator alone is a task. Becoming even a consultant also is really a task. Okay, these are some general points what I have earlier shared with you. One thing, not a good news for chartered accountants, is that domestic tax dispute, we cannot arbitrate. We cannot take tax disputes and assessment done by the authorities. We cannot arbitrate. It can be, ultimately, you can go to only a settlement commission, if at all there is a settlement or a possibility of settlement. Otherwise, the tribunals, whether it is a direct tax or indirect taxes, it cannot be arbitrated. that is well settled. But international taxation is possible to be taken to arbitration, not domestic tax. That is one rider for professionals like you. And all other financial disputes you can arbitrate subject to existence of an arbitration agreement. Okay, here some informal points what I wanted to share here. When there is a dispute between two parties, they first go to their chartered accountant and not to an advocate. I have to confess here. Every client, if you are asking, at least having some commercial transaction, they'll say that, sir, my auditor told this. Straight away he'll say, my auditor, no, nothing wrong in it. My auditor is guiding like this. So whether I can go and move and finalize like this. In a very informal way, they'll have the discussion. Whether they are individual or even a corporate, they have the discussion starting like this. Nothing wrong in it. This is your opportunity. This is what I feel from last 2 decades of my exposure in arbitration. Your opportunity is there within your purview. You don't allow it to come to advocate. You can explore it. Explore in a constructive way. You guide them. If you can guide them, they won't come to us. Let the filtered one comes to us. Really complex issues come to us. Really a legal interpretation has to come to us. Not all the issues. Secondly, day in and day out, a CA is engaged in resolving disputes of his clients, though informally. I'm happy to say that even in my individual capacity, when I have a dispute, when I have an issue, whether a family issue or a Hindu undivided family management of the properties, instantly I'll call my uncle auditor. That's all. Even as a lawyer, we are very confident dealing with chartered accountants. That is the greatest opportunity. Day in and out. Advocates are not there to guide the parties every day. Advocates are there only when a dispute arises. Chartered accountant is a person who are there going along with the life of any individual citizen who is coming under the tax ambit, who is coming under any commercial aspect or commercial activities. They are part and parcel of their life. That has to be constructively evolved as a role, a career opportunity for you to take it to ADR. It can also be mediation. And finally, the chartered accountants also has extensive, sorry for using that word also, but anyway, it is prepared by a lawyer, we try to put it, extensive experience of drafting commercial agreements, negotiating with government authorities, and ultimately representing clients in number of ways. You are the first platform. You are the person who are drafting commercial contracts. You are the first person who are taking the disputes to the proper forum for dispute resolution. Then only it comes to an advocate or to the courts. That first opportunity, you can easily tap it off. Don't ever give opportunity for other professionals. Try to explore and solve that. You can also use a mediation and solve it. That is always better. Because mediation, we don't have a law. It is totally informal. In future, there might be a law. Right now, we don't have. As a mediator, you can constructively even finalize JV agreements. So much of opportunities there. You are the best mediator. You can turn your role as a negotiator to mediator and bring the other party and solve the issue in your office itself, but in a professional manner. Don't do it for pro bono. Pro bono is good only for certain period and for considering the financial position of the parties. Most of the issues, you do it in a professional manner. Okay. What are some initial steps for a chartered accountant to become an arbitrator? Some of the points what I wanted to highlight. Try to regularly read some journals. There are several arbitration journals are there. Now it's all available free of cost. If you are associated with some professional bodies, subject to your subscription, you can also get some journals. In India, it is always better to become a member of Indian Council of Arbitration. I'm not marketing that institution, but that was the first institution which was created under the Ministry of Finance by the Federation of Indian Chamber of Commerce and Industry, one of the oldest. Then try to attend training programs and also do postgraduate diploma or certificate courses in ADR so that you can strengthen yourself in the subject and be alert to opportunities, particularly suggest remedial measures to clients while calculating outstanding. Give several options. When a client is approaching, I think you are the best person. We lawyers are confining, okay, take it to the court, we can file one case, later we'll multiply into 10 cases. But it is not like that. Chartered accountants are very constructive and you just guide them with several remedies, several constructive remedies. That is a good opportunity for you to become an arbitrator. Because when you sit as an arbitrator, you are not always going to decide. You are also going to facilitate settlement. You are also trying to get an amicable settlement out of the dispute which has already arisen, and you are the best person to suggest alternatives, suggest alternative remedies, and particularly while calculating outstandings. Here some of the accreditations which is required. Most accredited arbitration training providers also have some professional diaries or directories of arbitrators where you can find abundant opportunity and promote your skills and work experience. Like opportunities can also be found in independent or specialized arbitration services, charitable organizations, independent advice centers, then the PSUs, regulatory bodies, as well as trade unions. These are some areas where we, as lawyers, we do get. You can also try as chartered accountants to explore these platforms. And these are some professional bodies. It is all in the chart, in the picture you can see. Those are some arbitration institution, prominent one. In India, I have just not highlighted because it is not so prominent like outside our country. If you see in the right bottom, ACICA, that is the Australian Center for International Commercial Arbitration. And in the left top, we can see ICDR, that is the International Center for Dispute Resolution in North America. All these are quite available arbitration institutions, which is some or even century old. If you can see one in the Europe, ICC, in the slide above also, the last point is given, International Chamber of Commerce. That ICC is one of the oldest arbitration institution, International Chamber of Commerce Court of Arbitration, which has time tested and is doing all constructive large international arbitration disputes. These are some examples for all of you to do a research and get your opportunities from these institutions. Yeah. And for young people, the second paragraph, if you are less than 40, that is young in arbitration, and you're eligible when you're 55 plus, there are also options to network with other arbitrators like Young Arbitrators Forum, and it is not confined only with these bodies, whether it is the London Court of International Arbitration or the International Chamber of Commerce or the Singapore International Arbitration Center or the Hong Kong Center, whatever, large arbitration centers, or even the MCIA, Mumbai Center for International Arbitration, they do have young groups. Less than 40, they are not charging fees for it, but you can get associated, become members of those young group if you're less than 40, and you have lot of technical discussions, the forums, wherein you will have networkings, and ultimately you'll get involved in not only domestic arbitration, but in international arbitrations also. Why I'm insisting? Because this is my, I think, 20th or 21st presentation for CA's opportunities, is that the proceedings are dependent primarily on factual merits and discrepancies. Please keep in mind, most of the disputes, particularly commercial disputes, are in the disagreements on the facts. And it is impossible for a legal professional to comprehend factual issues, because legal professionals like me or any other lawyers are best in interpretations of the law, but not on the facts. Understanding the facts, understanding and acceptance of the factual situation is left to technical experts. One such technical expert is chartered accountants. And when it comes to financial aspect, the factual merits and discrepancies can be best evolved by only a chartered accountant or a cost accountant. That is why I am insisting that all the four opportunities can be very well explored by all of you, and ultimately at one point of time you can sit as an arbitrator. Get associated with all these institutions. Once the Arbitration Council of India is there, try to get yourself accredited. Then, most interestingly, incorporate arbitration clause. Now, from now onwards, you have a great interest. Create your interest, and as a motto, incorporate arbitration clause in all the agreements which you are going to draft with the consent of the parties. That is going to give a great opportunity for you as a counsel or consultant, for other colleagues as an arbitrator. In your case, in your contract, in your client's contract, you are going to designate only your colleague, your friend, subject to the 5th and 7th schedule of the Arbitration and Conciliation Act. And arbitration, as other ADR mechanisms, is obviously a promising platform, particularly for chartered accountants and company secretary. The present day, the increasing scope of arbitration between business practices, CAs, sorry for mentioning it small, can add ADR as a positive addition to the skill he or she can offer to his or her client. Once you have established yourself through arbitration work and receive the professional accreditations, you can ensure a more authenticated platform or mode of executing your role or a job. Combined with your factual knowledge, it can be instrumental in resolving the complex disputes by utilizing the wide range of experience. This is what the observation, what I found from various cases involving high technicality, particularly financial and secretarial issues, when corporates, whether private or public, are involved. Thank you. Thank you, friends, for giving this opportunity, and forgive me for any informal comments what I have made. If you people are having a dual qualification of law also.
Thank you so much, sir. It was a very great presentation. In the very detail, you have explained the opportunities which the CAs have in the arbitration and how the arbitration works, goes, and everything. I would request if any members have any query, they can unmute themselves and ask our speaker.
Is there any? Yeah, anybody else wants to question?
Jitendra bhai? Hello?
Sir, is there any limit to the number of arbitrations that a non-judicial member can undertake?
As of now, there is no such limitation. The only thing is that it's all subject to your availability. When you're just engaged with your normal professional activities, you also have to have reasonable time spending for arbitration. And now an arbitration has to be completed, at least domestic arbitration has to be completed within 12 months or the maximum of 18 months, which has been prescribed by law. Your only availability is very much required. If your availability is there, you can take thousands of arbitration in the same time.
So,
Yes, sir. Yes, sir. Sir, your voice is not clear. No, sir, it's still not clear. So you can write in the chat box. Sir, I have a query. I'm not quite sure if this is the right forum to ask or not. But there are certain financial transactions which parties have entered, and there's some dispute in that. So how should the arbitration should go in for those certain financial transactions?
Can you repeat it? I can't get your question.
So maybe some two parties have entered into some financial transactions, off records transactions, of book records. So, and there's some disputes.
Okay, one thing, it is a settled principle that we can't have an arbitration based on an oral arrangement. Any arrangement, whether it's a financial or any arrangement, if it is put in writing, then only we can explore this opportunity of arbitration, but we can do mediation. Arbitration we can't do.
So still, even if we mediate and we give some sort of conclusion, so is there any legal repercussion on us?
One thing, as your general contract principle says, you can't just agree or you can't have a conclusion which is forbidden under law.
Okay.
Yeah, I think I have reasonably conveyed the message so that
no, I got it.
No information is there, questions is there.
No, sir, maybe just. Okay. Hello, Jitendra sir. Hello. There's some connectivity issue from his end, I guess.
Okay, what I'm suggesting, Mr. Gaurav,
yes,
you can later share it through email. What question is?
Sure, sir.
So that I can respond through email.
Yes, sir. I will do. So thank you so much for your time and for delivering the session at our study circle. I will request Ashish to please give a formal vote of thanks.
Thank you, Gaurav. Thank you, sir. Thank you for such a wonderful session today. It was really very simple, easy to understand, and a great presentation for a sneak peek into the ADR forum. And I'm sure the new forums that you have suggested of arbitration, conciliation, the dispute resolution, drafting arbitration and mediation clauses in partnership and other deeds, all of these which you have suggested will certainly be considered by our study circle members, and it will help them in furtherance of their profession or business. Thank you for not only showcasing these opportunities, but also guiding on what path to take to start and walk on these forums. Thank you for your valuable time today and appraising of all these opportunities. We hope to see you soon again.
Thank you.
Have a nice day.
Thank you so much.
Thank you, sir. Thank you.